things set up the way they're supposed to be. There, that's better. Hello, folks. And today is Thursday, and that means it's another day to record Legit Podcast Pro, the weekly short format legal and business podcast for podcasters. And I'll be getting going in that in a few minutes. Right now, I'm just sort of getting things situated for the talk today. We're going to be talking about some basics about copyright law, the Digital Millennium Copyright Act, and some small claims kinds of actions that are going on in the Copyright Claims Board. And I hope you'll enjoy that. But first off, I'd love to hear from you, I should say. If you're watching live, I'd love to have a little chat, say something in the comments. I've got comments coming in from Facebook, Twitch, Twitter, and YouTube. And LinkedIn, I think, also can do it. So I'd love to just say hello if you're already watching, joining us now. I'll be doing the recording in just a few minutes. And if you're not watching live, but you'd like to let me know you're watching, just a hashtag replay or just a hello would be delightful. And if you're not already doing so, hey, follow me and the show on whatever social channels you are using. I'd love it if you would do that. And of course, on YouTube, you can subscribe. Click that subscribe button. And if you want to get notified when we go live to do this, of course, there's that little bell icon. Click that bell and let me know that you'd like to be notified. And YouTube does that for me, for us automatically. And I should also invite you to join my Legit Podcast Pro group. If you go to legitpodcastpro.com, we've got a Facebook group, and I do occasionally offer some custom specialized training for Legit Podcast Pros who are members of the group. You can find out everything you need there on legitpodcastpro.com, or just visit the group on Facebook and join, and we'll get you in there as well. All right, I guess what I'm going to do is just jump right in and do my recording of the show and get things set up and established and fixed and ready to go. So let me get my button screen here ready to go so I can do the things I need to do. And we'll get this going here in just a second. Today is the 6th day of April. Can you believe we're already into Q2 of 2020? What is it? 2023. And I'm gonna test out my teleprompter real quickly here. Copyright law, the DMCA, and the Copyright Small Claims Court on this issue of Legit Podcast Pro. Okay, feels like it's a little fast. I may have to stop and do this again, but we'll see. Let's see if we can make this go in a single take. So here we go. Copyright law, the DMCA, and the Copyright Small Claims Court on this issue of Legit Podcast Pro. Hi, I'm Gordon Firemark, and this is the show. Here we go. All right, welcome to another episode of Legit Podcast Pro, where we talk about all things legal in the podcasting world. Today, we're going to dive into the topic of copyright, the DMCA, and the so-called Copyright Small Claims Court, the CCB. In this digital age, copyright infringement has become a common problem. As a content creator, you have to know and respect the rules for using other people's copyrighted material in your shows, and you have to have the right to protect your intellectual property from unauthorized use. The DMCA, the Digital Millennium Copyright Act, provides an easy and useful mechanism for you to do so. So, first, I'll give a quick explanation of copyright law basics just so we have context. Copyright is a bundle of exclusive rights that belongs to the author of an original work from the moment it's created. That's right, there is no requirement that you register a copyright or that you do anything more than create something in order to have copyright protection. And in the US, there is a registration system available. And if you're going to sue someone, you do have to register. But the protection begins when you create something original. And that means that nobody but the author or the owner, if the author has sold or transferred those rights, can make copies or distribute them, perform or display the work, or make things based on or incorporating the work. So, what do you do if you discover that someone out there has done these things to you with your property? Well, you can sue, and that can be time consuming and expensive and headache inducing and all that. But if the infringement is online, there's a cool system. You can get it removed pretty quickly and easily using the part of the copyright law called DMCA. DMCA stands for the Digital Millennium Copyright Act. This is a United States copyright law that criminalizes the production and dissemination of technology, devices, or services intended to circumvent measures that control access to copyrighted works. That's the what do they call it? You're not allowed to remove the digital watermarks and copying countermeasures that might be incorporated into a work. But it also gives companies that provide a service of allowing user-generated content to be uploaded. It gives them a special safe harbor from litigation. So they can't be sued for copyright infringement when their users post user-generated stuff that infringes, as long as they follow a procedure that allows for the takedown of the material when the service, like a YouTube or a Facebook or Twitch or Twitter, LinkedIn, you name it, when the service is notified of an infringement and they take it down, they are then immune from the lawsuit, as long as they have certain policies and those kinds of things in place. I'm not going to get too deep into the weeds on that, but let me tell you how it works. If you're a content creator and you find that someone has used your copyrighted material without permission, you can issue a DMCA takedown notice. A properly formatted DMCA takedown notice will include a description of the copyrighted work and an explanation of who owns it. It'll tell where the infringing material is to be found online, and it'll provide contact information for the copyright owner, along with that demand that the material be taken down. And once that notice is received, the service provider has to act expeditiously to remove or disable access to that infringing material. And the service provider will then notify the alleged infringer of the takedown and provide them with an opportunity to file a counter notification. The counter notification is a response from the alleged infringer that says the material was removed or disabled by mistake or misidentification or in error of some sort, usually because, hey, it's fair use or I have a proper license or those kinds of things. If a counter notification is received, then the service provider has to notify the copyright owner, and then they have to restore the material within a specified time period. That's usually 10 days or less, unless the copyright owner goes to court to get an injunction against it being reinstated, and that's the beginning of a lawsuit, essentially. So, what happens if someone abuses this DMCA procedure? And it does get abused from time to time. Well, a DMCA takedown notice is a powerful tool, but you do have to use it responsibly. If you issue a takedown notice and you don't have a good faith belief that the material is infringing, like if you know or should have known that the copying would certainly fall under fair use, or you're not actually the right copyright holder, those kinds of things, you could be liable for damages. And that can include the other side's attorney's fees, which can add up very, very quickly in these cases. And it's also important to note that the DMCA does not provide a complete solution to copyright infringement. It only applies in this space of online service providers, websites, and social media platforms, and those kinds of things. And if someone is using your copyrighted material in other media offline, well, then you're going to have to take legal action through the court system. And now let me just give you a quick message from our sponsor, me, and then we'll be back with more. Podcastlawforms.com. This episode is brought to you by Easy Legal Forms and Templates for Podcasters. If you're a legit podcast pro, you want to protect your intellectual property and ensure that content is used appropriately. Easy Legal Forms and Templates for Podcasters can help. Our form store at podcastlawforms.com provides a variety of legal forms and templates specifically for podcasters, including host and co-host agreements, DMCA takedown notices, release forms, and much more. With these easy downloadable templates, you can customize the forms you need in just minutes. Plus, our affordable bundle and a la carte pricing makes it easy to get the protection you need without breaking the bank. Visit podcastlawforms.com today. Easy, legal, affordable forms and templates for podcasters. Podcastlawforms.com. Now let's move on to the topic of copyright small claims. The Copyright Royalty Board, not the Copyright Royalty Board, the Copyright Claims Board, the CCB, is a government body that handles disputes over copyright in very small amounts and situations. It is a way of avoiding costly, time-consuming federal court litigation. It has limited jurisdiction and limited remedies, but it can be useful as a tool for resolving disputes over royalties or not royalties, over infringements that are sort of small in scope and limited damages. So you wouldn't be able to collect quite as much money in damages as you might in a traditional district court suit. It also provides an alternative, essentially, to this time-consuming federal court. So one of the benefits is that parties are allowed to represent themselves without an attorney. Now, that doesn't mean you have to go without an attorney, and that's one of the differences between sort of traditional small claims courts and this system. But this could also be a disadvantage because you may not have the legal expertise to navigate the process effectively. There are problems with this. There's uncertainty over the amount of damages that will be awarded. There are formulas for calculating damages, but the final amount can be sort of difficult. It's a newish process, so some of the mechanics haven't all been completely worked out. But some of the cases and controversies that have been filed and resolved then since the CCB was formed involve concerns about getting the right paperwork filed the right way, proper documentation, proper evidence filing, and the need for how do you bring in expert witnesses and those kinds of things. So the Copyright Claims Board, folks have had difficulty navigating the process, and there's that. But it is a valuable resource for content creators and copyright owners. It's that streamlined process. It's a voluntary thing, so yeah, either party can ask the other to, hey, let's do it this way, and save ourselves some time, energy, and money. So far as I understand it, only a couple of the many hundreds of cases that have been filed in the CCB have actually been proceeded to a final judgment. A lot of them get rejected right out of the gate because the parties haven't made the right allegations and things like that. So there is a little bit of trickiness to it. You're in the legal court system and you've got to know what you're doing. But we're seeing cases involving photographs. We're seeing cases involving music. And it won't surprise me one little bit that we start seeing cases involving podcasts using those things or others, or clips from each other's shows and things like that in the CCB, the Copyright Claims Board, that so-called small claims mechanism. So to wrap it all up, the copyright and the DMCA are important issues for content creators in this digital age. The DMCA provides this mechanism for protecting your intellectual property from unauthorized use with those takedowns I described, but it has to be used responsibly. And the CCB provides this alternative to lengthy, time-consuming, expensive court litigation for resolving certain copyright disputes. But parties have to be prepared to navigate the process effectively. So by understanding these issues and taking appropriate action, you can protect your rights and ensure that your work is used appropriately. And that's going to be it for today's episode of Legit Podcast Pro. I want to say thank you for joining me. I'm Gordon Firemark, the podcast lawyer, and I'll see you again next week. All right, I am back. And if you're here watching, I'd love it if you'd say something in the chat or the comments so I can give you a little quick greeting and we can chit chat a little. If you got questions or concerns or whatever, I'd love to try to respond to those. And also, hey, just don't forget that you can follow the show. You can follow me on social media. I hope you will do that. And hey, Rick, nice to see you. Thanks so much for that. Rick says, good info, Gordon. Thanks. Don't forget to subscribe on YouTube or whatever channel you're watching on. And if you're going to subscribe, you might as well click that bell, that notification button, so the system will let you know when I go live and do these things. And I look forward to it. Yeah. Rick, so what's new with you, man? Catching you. I don't usually see you this time of day on the socials, but it's nice to catch up with you. How are things going in your world? Over here in California, we are finally getting a little sense of spring. It's 70 degrees here in my area. And Rick, you just got home from work. Good. Yeah. And the weather here is nice. Just had a little long weekend with the family out in the Palm Springs area, visiting with my folks and my sister and her family. And we've made that a spring break tradition when our kids are out from school. So that was fun, but means coming back and, jumping on things and getting back to work. So I appreciate you dropping by, Rick. That's really, really nice. I hope the topic was sort of interesting for you. I have started embracing AI and ChatGPT in particular. When I create the outlines for the topics I talk about, I often ask ChatGPT, hey, help me find an outline on this topic. And it will give me, 5 or 6 talking points, and then I flesh it out with my knowledge or my research. And that's kind of fun. I hope if you haven't tried ChatGPT, it's worth it. It's worth it. You do have to fact check because they do make up answers sometimes. But and I did encounter one little blunder in here. It kept using the wrong abbreviation in my script that I was working from, but I fixed it on the fly. So anyway, you've had to issue DMCA takedowns on numerous occasions. Yeah, it comes up. It comes up fairly frequently. Actually, I should say that over on the podcastlawforums.com site, we have a sample of a properly formatted DMCA takedown notice available that will save you a lot of money on lawyers if you're not a do-it-yourselfer for that kind of thing. And let me see if I can get that into the chat messaging there. So it's podcastlawforums.com. Properly formatted. Now, a lot of the services like YouTube, they have forms on their site. Click here and make your complaint and those kind of things. Again, it's important to know what you need to put into those blanks so you can give them a properly formatted thing. I was just talking to somebody earlier today who's in the business of responding to those kinds of complaints, and he was saying that typically it's only about 1 in 10 of the demands for takedowns that he gets is properly formatted, and that therefore they have to legally comply with it. Most of the time he has to sort of coach them through, getting it right. And the problem is you don't want to be, if you're the provider and you're the one who has to take it down, you don't want to be in the situation of taking it down when there wasn't a proper formatted complaint, because then the person who posted it can accuse you of taking sides and those kinds of things. So got to be careful. Yeah, Rick, you write articles and product descriptions that have been stolen by competitors in the past. Am I correct that you are in the wireless radio technology business or something like that? Is that correct? But yeah, companies that put their products and things online, write descriptions and sales copy and so on, and you spend a lot of time and energy and resources, money, on getting the copy right for your ads in your promotional material, and you don't want your competitors just coming along and cut and paste. Yeah, so you sell two-way radios. Yeah, so that's pretty cool. But yeah, competitors will come along, and unscrupulous competitors anyway will come along and rip you off at the drop of a hat. So that's it's a shame. And the DMCA is useful for that kind of thing as well. So it's not just for media content creator, copyright like music and film clips and things like that. You can use it with blog posts and ad copy and a lot. Where a common area this comes up in is when you post photos or images of the products that you spent the time, energy, money, and resources to make the photographs, and then your competitor comes along, just copies and pastes your photograph of the whatever the product is. Now, companies that make this stuff often provide images of their products for everybody to use. But if you're going to go to the trouble of making your own photos, you want to make sure that they're yours, right? And there are technical countermeasures. You can watermark things and those kinds of things, but the DMCA takedown notice still becomes necessary from time to time. So, well, listen, I think I'm going to call it a day unless you have a question or comment for me. Thank you for being with me today, and I'm going to go and wrap this up so I can publish the audio version of this episode in a few minutes. Have a great one. Take care.